going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
Oh, what's going on? This is Colin. How's everybody doing? Hope you guys are having a great day so far. All right, I've got two good ones for you. Yeah, that's about all I have to say, really. I don't really have anything else about the intro. I've got a Judge Goggins and a Judge Slavin clip, both out of Michigan. Okay. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
How about the William Trier Family Trust versus Kelly Irwin?
Here, Your Honor.
And then with Kelly Irwin, I got you, and boy, I've got a lot. No plaintiffs. Anybody
I'm
with?
here. I'm Jake Trier.
Oh, there you are, Mr. Trier. Yep.
Yep.
Got there. This is an adjourned date. Miss Irwin, did you speak with legal services?
Yes, I did.
Are they sending you, or are we proceeding without them? I'm sorry?
Your Honor, we spoke to Ms. Irwin and we're declining to represent on her behalf.
Okay, thank you. Thank you. Mr. Trier, and you're the, if I remember right, you're the trustee for the trust, is that right?
Correct.
In fact, I thought I saw, oh yeah, I've got an order in the file. Mr. Trier, why don't you raise your right hand for me? Do you swear from testimony you're about to give will be the truth?
Yes.
Okay. And let's see, is this property that the trust owns at 5324 Southway Drive, Swartz Creek?
Correct.
And was it being rented to Kelly Irwin, or is it being rented to?
No, it was not.
No? Was she on the property at one point?
Before her and my father divorced, she resided there.
Okay.
Once he passed away, she broke in and started living there.
Okay, when you say, I guess help me out with broke in. Was she still living there when she came back on the property or anything?
No.
No? Had she moved out? Do you know?
Yeah, after their divorce, she moved out in 2021.
Okay, when did she come back on the property, I guess, when?
I believe the first time that we had police interaction with her being there was September of 23.
Okay. And were you the trustee of the estate at that time?
Correct.
So in, I guess, September of 2023.
Oh, don't do that. It is way too early for tech issues. I can hear it just fine. Can everyone else hear it? I feel like Doc Ock isn't the one to mess with me, but maybe he is. Maybe he is. Psst. What's up, Lone Wolf? What's up, buddy? Yeah, please tell me you guys can hear it. I'm waiting for. Okay, Amanda said yes. Scaff. I feel like Scaff's gonna mess with me. Lone Wolf raid. Mrs. Lone Wolf. Thank you so much for being here, Mrs. Lone Wolf. And yeah, thank you so much, Lone Wolf, for the raid. That is awesome. Thank you. Just got finished watching Judge Fletcher with you. Yeah. All right. Thanks, Lone Wolf. Okay, let's keep going. But yeah, I feel like there is sound, and Doc Ock just trying to get in my head early. That's what you do, right? When the game starts, you get in someone's head. Then they messed up all day.
Did you, I guess, you have some contact with her?
Yes, I had showed up because the neighbors told me she was in the house. So they, in the meantime, called the police. So once I got there, I showed the police the new trust that my dad had done after their divorce.
Okay.
And I told her that she had been omitted from the trust that day. And they made her leave at that time until she had paperwork obviously showing she belonged to the home.
Hi, Linus. Now that I know how to properly pronounce it, I thought everyone else was mispronouncing it for the last, I don't know, month and a half, 2 months. Yeah, I thought I was the one that was right. Yeah, Linus. It's not Linus, everybody. It's Linus.
Or in the home.
Okay. And after giving her some notice that she should move out, she still stayed there, is that right?
Yeah, she's still there to this date.
Still there, okay. Ms. Irwin, anything you want to tell me?
Yes, Your Honor. I also have a witness here with me that was there the day that my former spouse died. We went over there, and I did not break into the home. I was under the power invested to me by the Second Amendment to the trust. And
Hold on. What you say Second Amendment to?
Whoa. The power invested in her from the Second Amendment to the trust. I'm guessing she means there's an amendment in the trust. She's not actually quoting the Second Amendment. That's what I'm going to assume. But this happened, I think this was last week, or this is not this past week, but over a week ago. So that threw me off. But this, all right. And yeah, whoever said it earlier, yeah, the beneficiary of the trust, he actually is. So it's the son of the deceased. He's one of the beneficiaries.
The trust, right?
There is an original and in 2001, and in 2016 he amended it to add me as and we were not married. He added me as a dear friend to the trust as first successor, and his son Jacob Trier as second successor. Then in 2017, him and his son, they always had a very contentious relationship. He disinherited his son in 2017 from the trust completely, and I was the sole successor and sole beneficiary. And that was the last of it. And then I received a phone call. He died July 5th of 23, and I received a phone call from a broker, a broker firm, that I asked how they got my name, and she said they had got it from Jake Greer. She had just spoke to him and his first wife, Sandy, and they both said he were very mean to her and said that he left everything to Kelly and that she would need to talk to Kelly. And I said, oh, I didn't know that. I said that I need to seek counsel. So I sought counsel, Ron Heldy, and he went through our divorce papers and he says, yes, it's yours then, go seize the property. So that's what I did. I said, well, I didn't know if you ever made a third amendment because it don't have to be registered. So then he talked with Peter Dorr, whom they are personal friends to, gifted gifts at Christmas and so forth. And next thing you know, magically a third amendment, it comes into play. Mind you, it's not valid, only has one witness signature, and that witness doubles as the notary. It doesn't have
Okay, rather than tell me all that though, the last, if what you say is true, I've got an order from Judge Barkey dated June 6th, 2024, says that Jacob Trier is the sole trustee of the William Trier Trust, Family Trust, that there was a quitclaim deed executed by Kelly Irwin and recorded in Genesee County records as property, and that property is at, let's see. Be located at, wait, they've got the legal description.
I feel like I should have given a little background to this. Now, this is a hearing because there was an appeal. There's already been a judgment ruled in the son's favor, and the ex-wife is appealing it. Now, the guy passed away. This is his ex-wife. They got divorced. I'm guessing shortly before he passed away. I don't know how long, but if she's in court fighting for this, I'm guessing it was shortly before. But yeah, so he passed away. Apparently, the son didn't have a good relationship with his dad while him and her were married, and that's what she's fighting. But now that she was written out of the will, she's arguing that she should still be part of it and she should still get something. And the son is trying to get everything that it says in the will. Okay, I think we're caught up to speed now.
described as lot 49 of Dye Road, acres, 5324, commonly noted, yep, there it is, 5324 Southway void. And that the William Trier Family Trust dated April 27, 2001 is the sole owner of that property, free of all claims and interests.
Yes, I'm aware of that. That's why there is a claim of right of appeal. And
where's the appeal?
the appeal is let me see, I got the number to it.
Your Honor, real quick, I believe my witness is trying to be admitted. I think someone has to admit him into the room.
Who's the witness, Mr. Chair?
George Reisig.
Yeah, I got him sitting out there. It's one of your witnesses?
Yes.
And so he put the eviction.
Sorry, I got to shout out that comment. You just made me laugh. Yeah, no, that's a good comment. Yeah, I can't stop laughing. No, it's good. That's good. And I had something else to say, but I was trying not to pause it, but I wanted to pause it because that comment was funny. Yes, he was. I don't know if he was written out of the will, but his role in it was Marsh. No, I can't think. I don't know what word I'm looking for. But when they got divorced, she was written out of the will. So since there was no one specifically in the will, the property or the estate goes to the next of kin, which is the son. That is what the court ruled on. All right, now we're caught up. Okay, let's go.
In before my right of appeal, what days was up. He put it in 12 days.
Why don't you hold on though? It sounds like we got more than you here. Mr. Isaac? I need you to unmute there for me.
Yes, Your Honor.
There you go. I just sitting back there. I didn't realize you were on this matter. I just called William Trier Family Trust versus Irwin Kelly. Mr. Trier, I was just trying to sort through things actually a little bit. I have actually, let's kind of start over. Mr. Trier and I guess Mr. Reisig, why don't both of you raise your right hands there? We'll start out over again. Do you swear from the testimony you're about to give will be the truth?
Yes.
Yes, Your Honor.
And Mr. Trier, just to get back to you first before Mr. Reisig testified, there was an order from Judge Barkey dated first page says June 6, 2024, but then the last page is June 13, 2024. It looks like that's it's like a second order, I guess.
Yeah, the first order was, it was ordered that all her motions were stricken and that I was named successor trustee. And then the second order is the one you're seeing filed on the 14th or the 13th.
Yep, she just did it in two separate orders. I got you. Okay.
Correct.
Okay. And then with regard, I guess is Mr. Reisig testifying for you for some reason then?
Yes, he's going to testify as to what happened in the higher court.
Okay, well, then, Mr. Reisig, you're under oath, and Mr. Trier, go ahead and, I guess, question him, and I'll let Mr. Reisig, he's an attorney, I'll let him kind of.
Okay, Mr. Reisig, pertaining to the trust, the William L. Trier Family Trust dated April 27, 2001, what ended up happening as far as who was appointed successor trustee of that order?
Well, first, let me always warn people never to refer to another court as a higher court when you're talking to a district court judge. Okay.
Okay.
Oh, I forgot he made that joke. I've actually wanted to. I'm gonna ask Fleischer, Slavin, and Judge King if that's actually an insult or if that was just a joke. Because Judge Goggins got a kick out of it. But no, I wanted to ask him that. And yes, tonight is my date night with Heather, so it is an early stream on Saturdays.
This is all new to me. This is not my business.
Oh,
Here's what happened. Mr. Kelly Irwin was married to William Trier. They were married for about 3 years, from 2018 to 2021. It ended in divorce. Mr. Trier, the William Trier, had a trust. The Third Amendment to the trust, which is dated February 25th, 2021, cut her out as a beneficiary and removed her as a trustee of the trust, and named Jacob Trier as trustee of the trust, and left the assets to, I believe, Jacob and perhaps his sister. The William then died in 2023, July 5th. At the time of his death, the trust owned this real estate. The trust had owned it for some time. The Judge Barkey saw a copy of the deed where he had transferred the trust. Mr. Peter Dorr had drafted the trust and all amendments and drafted the documents that transferred this property into trust. After he died, about 2 months after he died, Kelly Irwin fraudulently, and these are the allegations in the complaint in the probate court that the judge found to be true and entered judgment on behalf of Jacob Trier, found that Kelly Irwin fraudulently executed a certificate of trust that said that she was the trustee. On September 26th, the judge found that she executed a fraudulent affidavit of successor trustee and recorded that at the Register of Deeds office, saying that she was the trustee. The judge also found that she fraudulently, on October 12th, 2023, executed a quitclaim deed, which purportedly conveyed the property to herself as trustee. Very odd deed. And then on March 27th, 2024, during the pendency of these proceedings, I believe, she executed another deed to herself from the trust. The judge found that that was fraudulent as well. The reason the judge found that it was fraudulent is because there's a section of the probate code, EPIC, that says, it's section 2807, that a divorce automatically terminates each spouse's rights in each other's trusts, wills, governing instruments of any kind, even insurance policies, as I'm sure the judge remembers from his time in practice. And so the judge entered the order on June 14th. It's signed June 13th, but it's stamped June 14th, saying she's not the trustee. She never has been the trustee. All the deeds that she signed and all the documents she signed are void, okay, ab initio, and set aside, and that marketable title of the property is in the name of the trust. And later, the other document that she entered declared Jacob Trier to be the trustee of the trust. So the way it stands today is Mr. Trier is the trustee of the trust. The trust owns the property free and clear of all fraudulent claims by Kelly Irwin. And that judgment stands right now. It's a final judgment, okay? Ms. Irwin tried to file an appeal. She got a defective appeal filing letter from the Michigan Court of Appeals, and that has not been cured yet. And I can give the judge, you can actually look it up on the Court of Appeals website. It shows that there is a defect letter issued to her sometime in early July, and she's not cured those defects as of today. I checked the Court of Appeals website today. So once again, that order, that judgment stands. And as the judge knows, there's no automatic stay. If she wanted to stay a proceeding, she would have to file a motion for stay of proceeding. She has not done that. And so here we stand.
All right. I actually was going to make a joke about that, Sashina, but you beat me to it. I was going to say something along the lines of, we haven't heard the word trust used so many times that wasn't a sovereign citizen. But yeah, he used it a lot. Also, good for the son for calling him as a witness, but I don't know why. This guy's an attorney. Why isn't he representing him? That maybe I don't know. I don't know the relationship, but I feel like it would have made more sense to be represented. Maybe the attorney said, you don't really need to be represented in this because there's no way she's going to win this. Maybe. I don't know. But great witness.
Okay, boy, I appreciate that, Mr. Isaac. So let me just kind of cut through that. Ms. Irwin, your argument with that you started to tell me about an appeal sounds like it was defective and you haven't cured whatever defects are with that appeal first.
No, Your Honor, I have 21 days from the timestamp date because I was told, and I even have my own attorney told me that I had 42 days. I have his text message and I started reading on my own and seen it was 21 and got it in at 11:38 on the day that was the last day to appeal. So now
Doc Ock, that's, coming, I actually think that you're 100% right there. Sorry for the quick pause, but I think you're right on that.
I'm taking it on my own. Legal aid isn't helping me. And so I have 21 days. They sent me a letter back telling me what else I needed to get, but I had to have at least the application in. So now I have to get the rest of it. And I have the transcript ordered. And so it's defective in that they don't have everything they need as of yet. And then I got to give proof of service and get these things to Jacob and so forth to appeal. Because it's not what the descendant wanted. He did not want his son to have anything, and I have.
Hold on, I'm just go by what I have.
All right. Judge said, hold on. So that gave me free reign to pause. Mayor, that was a beautiful service this morning. And that was a great speech, or what's the proper word? Words. Anyways, you did great. I was moved. I was listening to it while I was doing some work, and you almost had me choking up. You did. It's good to see you, Mayor. Hopefully you're doing well. And yeah, today's service was beautiful. But yeah, I really hope you're doing as well as you possibly can right now. Eulogy. That's the word I'm looking for. Thank you. Thank you, Drunk Beaver. What the word that was going through my mind was what Zoolander said. And I can't even think of the right word he did, but I know he massively butchered the word. And I was thinking, what did he say? Because whatever he said wrong, I gotta say the right word. Eulogy. Thank you.
Have as far as orders right now.
Oh yeah.
So I've got that, and you're telling me you're in the process of getting your appeal cured. But is there a motion to stay this procedure? I don't see anything. I don't see anything anywhere that even from an appellate court, anything.
Right, because I was trying to get help from legal aid, and they're telling me, and then I went to a legal aid out of town, and they tried to help me a little bit. And matter of fact, they told me that I needed to request this to be dismissed on if an eviction comes from trust, it has to have an attorney for the trust, not pro per.
Okay, so I guess you're at the point now, why would I dismiss this case when everything points to there's no appeal right now pending and there's no motion to stay pending? Why would I
That was absolutely it. He said something like, are you here to tell me how bad of a Googleizer I am? That's exactly what it was. Thank you so much, Doc Ock.
The appeal is filed. It is filed, and they're just waiting on me to get the rest of the paperwork in.
But you've got no.
I have the case number 371553 timestamped. And I have a friend here that friends with Mr. Trier, and he can even he's going to witness to what Mr. Trier wanted in regards to this Third Amendment being fraudulent. That's the only thing that's fraudulent. And Jacob's been using his position as a court officer and close relationships with attorneys to get this through and just take away the final wishes of the descendant.
If I may.
That part's not even up to it. Mr. Reisig, I guess I have a question for you then. She's telling me that she's got something in the process of correcting whatever defects there were. Do you have anything other than what she just told me?
No, I can call up and I could project to the court screen right now, the Court of Appeals, which shows the last entry there was she has a defective filing letter. I have a copy of the defective file letter that I can show the court right now on the screen if the court will allow me to share. The only thing I'm suggesting is that even if her appeal was perfect, there's no stay. And that would be staying the other proceedings. Yeah. And she cannot ask another court, for instance, a probate court, to stay your proceedings. These proceedings are not before the appeals court.
I object. I can file for immediate consideration.
Immediate consideration is different than a stay.
Yeah.
Okay.
Yes.
The worst part is when the guy passed away, she moved into the house that she thought was hers. She just instantly moved in. and the son wants her out so he could sell the house, and he can't sell it while she's there. That's that's what a lot of this drama is about.
And I've got, so Mr. Isaac, you're not aware of any motions pending for stay at all from?
There are no motions pending for stay, and I believe Ms. Irwin said she had not filed one.
Yeah, okay. All right.
But Judge, if I may, here's
Sure.
what's happened. When she moved into the house, okay, the house went into foreclosure because nobody was making the mortgage payments. The mortgage foreclosure occurred April 10th, 2024. So it's been 3 months now, and she has not made those payments, even though she claims to own the house. The Mr. Trier is trying to get the house back so he can sell it, and before the foreclosure redemption period runs on October 9th. Ms. Irwin, I think this is just a stall so that everybody loses. I think that's what this is all about. Because she has no chance of winning the appeal under section 2807. I lost an appeal under section 2807 because I was trying to stretch, trying to get clear.
All right, and this is where my awesome editing skills come into play. We hear Judge Simpson's court coming back in after his, I don't know, 3-hour recess. So I'm gonna just fast forward about 10 seconds. Hopefully, we're just gonna rewind a little bit. We're not gonna be too far off.
Maybe there's some wrong with that, but
Because there is.
And that would be staying the other proceedings.
Yeah.
And she cannot ask another court, for instance, a probate court, to stay your proceedings. These proceedings are not before the appeals court.
I object. I can file for immediate consideration.
Immediate consideration is different than a stay.
Yeah.
Okay.
Yes.
And I've got, so Mr. Isaac, you're not aware of any motions pending for stay at all from?
There are no motions pending for stay, and I believe Ms. Irwin said she had not filed one.
Yeah, okay. All right.
But Judge, if I may, here's
Sure.
what's happened. When she moved into the house, okay, the house went into foreclosure because nobody was making the mortgage payments. The mortgage foreclosure occurred April 10th, 2024. So it's been 3 months now, and she has not made those payments, even though she claims to own the house. The Mr. Trier is trying to get the house back so he can sell it, and before the foreclosure redemption period runs on October 9th. Ms. Irwin, I think this is just a stall so that everybody loses. I think that's what this is all about. Because she has no chance of winning the appeal under section 2807. I lost an appeal under section 2807 because I was trying to stretch, trying to escape the clear mandate of 2807 that an ex-spouse gets nothing.
I object.
Well, you can object to maybe Mr. Isaac's legal skills, but maybe there's some wrong with that, but.
Because there is exceptions to revocation upon divorce.
Okay, I think what Mr. Isaac's telling me is accurate, quite frankly. What, Mr. Trier, I guess from, is that part correct, that there's a redemption period that runs October 9th of this year?
Correct. And I've already got the money to redeem set aside in another account, and I'm in close contact with the third party purchaser, so he's very aware of what's going on.
Okay.
And I've already got the payoff through a certain date. I just need to obviously get her out of that house.
I had a chance to review the documentation that's been filed with this court with regard to the orders from Judge Barkey, and I heard testimony from Mr. Isaac as well, and he's always been very trustworthy as far as what he's told courts before, including me. I guess, you know what, I guess before I just kind of jump to conclusion, Mr. Isaac, why don't I give you just a chance? Can you pull that up for me just so that I don't?
The Court of Appeals?
Yeah, why don't we do that, just to cover everything, I guess.
Yes, sure.
Let's just do that just to cover everything.
She moved in. Once her ex-husband passed away, she moved in. She thought that she was in the will still, and so she just moved into the house that she thought that she was going to be in possession of. Only to find out that the husband or her ex-husband took her out of the will after the divorce. So she's no longer named in there. And yeah, so now the son is just trying to get her out so he can sell the house. But yeah, she just moved into the house once he passed, thinking it was hers.
Everything here.
Let me open it up here.
Sharing.
Your Honor, can I also show my Court of Appeals where they sent me a letter saying the things that I needed to
That's what I'm
correct?
gonna call up. That's what I'm gonna call up, Judge.
Okay, so he's gonna call both, and Ms. Irwin, just look, make sure that they're what you wanted me to look at too, okay?
Yeah.
Okay.
There it is, Judge. I don't know if you can see it.
Yep, I got it here, Miss Irwin, just for your sake too, you got that?
Hang on.
Have it right in front of you.
I was muted the entire time. I'm sitting there telling you guys how it's blurry on my screen, and I'm looking. I don't see any addresses. I don't want any personal information on this. If there is, I might get in trouble. So I may not be monetizing. I forgot this was in here, but I'm just quickly looking over it, and I don't see anything, any personal information or anything. But if you guys do, please let me know. But it's really hard to read on my screen. Maybe you guys can see it more clear.
Hold on, baby. Yeah. I
Judge,
can't read that. And it won't zoom bigger.
Well, it's a letter dated July 8th, 2024. It's from the Court of Appeals. The crux of it says unless the bottom is filed within 21, the above is filed within 21 days of the date of this letter, your case may be dismissed for failure to pursue the case in conformity with the rules. And that goes on from there.
Yes, that's correct. 21 days from July 8th. So I'm still within that, and I've been working on this eviction case.
And so do you have a motion to stay proceedings at all?
Well, that's what I was working on. I was at the law library all day yesterday trying to figure this all out because legal aid won't help me. And then they're telling me that I got to try to call the Michigan Bar Association. I'm working with it the best that I can.
I see, but you don't have anything filed right now.
Go today. Yeah, I can go file today.
Wow, man, we're in the middle of a hearing right now.
I mean, just for the motion to.
I can actually give you the exact date. It was over a week ago. I think I still have the original court clip. That's a good question, and I feel like that's an important one. Yep, it was July 23rd was the day. July 23rd this happened. So yeah, about 11 days ago, almost 2 weeks.
Say or just and or the other way for to have this dismissed on the fact that it's brought pro per instead of by a trust attorney.
I'm sorry, how does that come into the?
Oh, for everyone else that's coming in late, and you probably missed this, everyone that's even been here since the beginning, legal aid at the very start of this hearing says we will not be representing her. We spoke to her and we will not be representing her. So they talked to her. I'm like, you don't have a case, and just backed out. Like, they're not going to waste their time. So yeah, so she did talk to legal aid, and they declined to represent her.
I'm saying the dismissal of today's eviction case because it's being brought pro per instead of by an attorney for the trust when it comes from a trust.
He's trustee of the state.
I understand that.
Yeah, he is. Your Judge, that refers to corporations, limited liability companies, and business organizations.
Victoria, good to see you, Victoria. Hope you're well. Hope you are well. Much deserved day off. Even though you weren't in the courtroom the last couple of days, you were just hanging out online. But still, Saturday, much deserved day off to you.
organizations. I think
No, I'm just kind of cutting through all of that. He's trustee anyways, and
Because I can do that, and his case is coming up next. So yeah, thanks for the question.
it just
right.
the whole argument's not making hold much ground. Given everything I've heard from both sides, including testimony, including Mr. Reisig's testimony and the documentation I just saw from the Court of Appeals, do find that there is still pending a defective letter sent by the appeals division, or I'm sorry, the appeals court. Items have not been cured at this point, and I understand she's got about another week to file for the cure.
Yes.
We have those cured, but it hasn't been cured as of today. There's no motion to stay these proceedings. Therefore, I can proceed based on those grounds as it is. Given all the totality of all the testimony, all the documentation I've seen from actually the orders from Judge Barkey, is
You know, if you change those names around, we can make a legal drunk Colleen. We can make her legally drunk. Sorry, that's how my head works.
as well, and the defective letter sent from Court of Appeals, I find the likelihood of this defendant winning at appeal is very unlikely. Therefore, I am proceeding today, and again, finding there's no motion to stay my proceeding as it is anyways. Do find that this property is property owned within the trust, the William L. Trier Family Trust. Trustee is Jacob Trier. He's filed this action. He is a trustee of this estate. And again, Mr. Reisig's correct. Most of that refers to corporations. This is a trust. Therefore, I'm allowing him to proceed for the trust as well. Grant motion by trustee Jacob Trier that this property should be greatly recovered possession by the Trier Family Trust from Kelly Irwin if there's anything outstanding. She's still living on the property. Allow a writ of eviction, give her 10 days to remove herself from the property, otherwise the eviction can occur. Okay?
Your Honor, could I request at least longer than 10 days? I didn't never get writ or nothing. I mean, I've got a whole house full of stuff. I just brought my son who was, he became legally disabled, blind from getting the COVID vaccination. So now I got his stuff there. I've got so much that I would have to move, including dealing with him and trying to get him disability.
Mr. Trier, do you want to give her a little more time, or are we kind of?
No, after dragging me through all this, absolutely not. She's had plenty of time to move.
Okay. Well,
I 100% agree with that. No, the son's right. Well, can I still call him the son even though the father passed away? Yeah, probably. Anyways, yeah. No, you did all this to yourself. Like, and now she's trying to play the sympathy card. And I understand what she's going through, but she did it to herself. She moved into a place she had no right to move into. She's essentially a squatter, and she's filing legal work. All she's doing is procrastinating her stay there. And someone said it earlier, and you were absolutely right. I think even the attorney said it, where if I can't have it, no one can. Because she's trying to get the bank to buy it back, and so then the son can't sell it. All right, this one's almost over though. We are moving to Judge Slavin. Don't worry, broken system, broken trust. I will be on Judge Slavin before you turn yourself in for your active warrant. I will. Don't worry.
writ of eviction after August 2nd.
Thank you.
Okay. Good luck to everybody. Mr. Reisig, it's good seeing you again. Bye, guys.
Thank you, Your Honor.
Bye.
Yeah, you have tremendous patience, Sean. Thank you.
Some days.
All right. Yep. That was a good one. I actually saved that for this weekend because weekend courts are slow, and I knew that was good. And it's Judge Goggins. Not a lot of people share Judge Goggins, so I knew I could hold off on playing it. But yeah, I don't know what she thought she was going to gain from that. I really don't. Anyways, let's move on to Judge Slavin. Kind of nowhere. I would say kind of the same situation, but nowhere near the situation at the same time. But we are talking about someone who passed away. The father of the family passed away, and this is a sibling fight over a will. But there's nothing to fight over, and Judge Slavin is just kind of giving all of his education speeches. So I enjoy it. So I'm sharing it. Let's go.
Mr. Beers, you had the opportunity to speak with Chavez Arnold. Was there any resolution in this matter?
We had opportunity to speak in breakout room. We were not able to resolve this morning, Your Honor. So plaintiff is ready to proceed to trial.
All right. All right, I'm going to put the two of you into the waiting room, and I'll pull you in when we're going to start the trial.
Thank you.
All right. Now, Melissa Gibbs and Thelma Bryant.
Right here. Your Honor.
I'm here.
Ready. This is a motion for possession pending trial. Don't see the motion. Hang on one second.
Don't worry, you're gonna figure out why. Where is panel link? You're gonna figure out why Judge Slavin's confused here in a second. You want to come up, broken system, broken trust? I don't share the panel link. I don't. No one needs to hear your comments about how you feel about Judge Slavin. And honestly, I don't know if I'm up for hearing your comments on them today either. But if you want to schedule a time up, I'll be happy to have a conversation with you, but not today. It's date night. I'm doing this just because it's early on a Saturday, but yeah. You want to review me and Slavin? No. That's what I just said. I said no. Yeah.
All right, so Melissa Gibbs.
Yes, sir.
Is your father alive?
No, sir.
Okay, my condolences.
Thank you, sir.
And you state that Thelma Bryant
Yes.
is your stepsister?
Half sister.
Yes,
Half sister? Okay, it says stepsister in your complaint. All right, and you're looking for a copy of the will.
It's a revocable trust.
Okay, so who's talking?
I'm Thelma. I'm sorry. I'm Thelma Bryant.
Okay, well, don't just jump in.
I
When ask you a
apologize.
question,
I
you guys-
apologize.
Well, seriously, this isn't the Jerry Springer show. So listen, has this gone to probate? Because this is probably a probate issue, not. Has this matter gone to probate, either party, Ms. Bryant, Ms. Gibbs?
No, it has not. Our mother is still alive.
Okay. And as far as the named beneficiaries that are in the trust, this is the trust that your father executed?
Our mother and father are it is a revocable trust, our mother and
Right.
father. So it goes to our mother. Upon our
Right.
mother's death, it would then go to us three girls. At that time, all three of us.
You say us three girls, what are the names of those three girls?
Thelma Bryant, Melissa Gibbs, and Lisa Baker.
Okay. So
at that time, we would all.
Why don't you give her a copy of it?
All right. Just trying to, thread the needle here. I'll explain a little bit of what's going on. So no, so the father was the biological father of two of the daughters, and then he remarried, and the woman he remarried to had a daughter. Now I believe that person is this Thelma person. So the other woman who was suing, no, she's claiming she filed a motion for possession. She filed a motion for possession of the will. She wants a copy of the will, and she filed the motion against her sister. That's what this is about. Okay, this is kind of wild. Judge Slavin was right. It's like, this isn't the Jerry Springer show. I mean, he's right. This one just kind of makes no sense, and Judge Slavin's going to let us know.
I don't have a copy.
Okay, who does?
Our mother does. I've never even seen it.
All right.
Melissa Gibbs speaking, sir. Can I say something?
Sure.
The reason why I had to file this motion is because my family, meaning my stepsister, Thelma Bryant, and my biological mother, we share a biological mother, basically almost immediately after my father passed, because my sister was from my mom's first marriage, funny stuff started happening, and I have had no contact with my sister, who lives 10 minutes from me, Thelma Bryant, since October 28th, 2022, because I asked her for a copy of the will, because my mother told me I had to get a copy from her because she was one of the executors. She said she had no idea. I did become unhinged and screamed at her on the phone. She was at my house and I screamed at her and, told her to quit playing stupid. And all of a sudden I'm blocked. And my biological sister, who is my father's, we're the only children that are blocked.
Sure. All right,
and
so
it's just real funny.
First off, let me just explain to you this. You don't have any possessory interest in a piece of paper. So I'm going to dismiss your case because this is a case of claim and delivery. What does claim and delivery mean? It means that there's some sort of chattel. Chattel is any property that someone can own. Matter of fact, children are even chattel. That's why you can't enter into a contract when you're a minor, because you're not a thing. You're not a person. You're a thing.
Yeah.
And that's why chattel is a dog, a car, anything you can own or possess. This isn't something that you possess. It isn't yours. It's in possession of somebody who's the trustee of the estate. So normal claim and delivery would be like, hey, I left my radio. We went over to a pool party. I brought my big boom box over to their house. We were jamming, having a good time. I forgot it when I left. Now they won't give it to me back. Judge, I need to get my boom box back. And here's my receipt that I own it. And I'll see, okay, hold on. Then I'm going to take possession of it here at the court. And I'll figure out at trial who actually owns it. This isn't something that I can do that with. I can't even effectuate the case itself because it's a trustee who holds the paperwork to a trust. If you wanted to, you would maybe do that in probate court when your mother passes away. And you also, if you want to, you can file for a transcript of this record, because Miss Bryant literally admits without question that the beneficiaries after your mother passes are Miss Bryant, Miss Gibbs, and the third daughter, the third sister. So,
all right, Victoria, enjoy your bestie's birthday and happy birthday to her. I hope you have a great night, Victoria. Enjoy your Saturday night and your bestie's birthday. Also, I will say this, broken system, broken trust. I do not care, and I actually like it when you're here because honestly, I like poking fun at you. But if you're gonna, I don't want, the personal things with you and your sister in the chat. We're not going to do that. I will ban you myself if you do that, or at least time you out. So, broken system, broken trust. This is your warning. Play nice. Play nice. Also, there's only about 2 or 3 minutes left of this. I got a bonus clip. You guys want to watch another Judge Slavin clip after this? It's my video I'm going to be releasing tomorrow. And you know my deal on bonus clips. When I do a bonus clip, you still got to go at least hit the like button on it tomorrow, if you would like. If you would like, you guys let me know. We got about 2 minutes, so if you want a bonus clip, we'll play it.
So you have it on record that she does admit that. So then you just got to wait. I mean, not to say that in any sort of morbid sense, wait for your mother's passing and then let the trust effectuate itself the way it should. As far as like what you're going to get or not get, or you want to take a sneak peek, or you're just going to have to wait and see. Because I can't force anybody, and Miss, she doesn't have a copy of it, that the trustee, which is your mother, has a copy of it. I can't force a trustee to give a copy of a trust to a beneficiary who's not even a beneficiary. You aren't technically a beneficiary until something in the estate paperwork kicks in. Like if you're in somebody's will, you're just nobody. You have the potential to become a beneficiary, but until that person actually dies, you're just a name on a paper that might maybe happen. So you're not technically a beneficiary until you're actually a beneficiary because somebody died. So I really have no way of effectuating this
Guys,
case.
I'm really sorry for the. Yeah, I was trying to go. Nope, he's okay. Hold on. It is paused right now for a specific reason, and I did it. So let me. All right, done. I warned him. I gave him a warning, and when I was trying to do it on my computer, I have to learn that when I want to put someone in timeout, I got to use my phone and not my computer. So my computer doesn't like multitasking when I'm streaming. All right, broken system, broken trust. We'll see you on a different day, but not doing that. Not doing that at all. Erica, you are more than welcome to be here, and yeah, for everyone who actually saw the messages that he left, yeah, he's full of shit. Okay, let's keep going, and then I'll play the bonus clip.
So I am going to, one, sua sponte, dismiss your case for basically for lack of jurisdiction and for lack of subject matter jurisdiction. And
happy birthday, Paloma Decky. Is it? I think it's Paloma. Please tell me I'm pronouncing that right. But happy birthday, Paloma Decky. Don't go too hard on Victoria. She has to show up to work on Monday. But yeah, no, I would love to see, her complaining she's hungover on Monday. That'd be hilarious. So go really hard on Victoria, Paloma. But happy birthday. Hope you have a great night.
As far as you could call your mom and ask for a copy, if she doesn't give it to you, she's the trustee. She doesn't have to. It's kind of like asking her for her driver's license. That driver's license is hers. You can't ask me to give you a copy of her driver's license. It's no different. She legally has the authority to hold and.
All right, I got to redo it. Happy birthday, Paloma Dickey. Sorry, I'm terrible at reading names. If you've been around my channel long enough, I am absolutely terrible. Paloma Dickey, happy birthday.
Keep that paperwork because she's a trustee.
All right, since I've paused it so many times over the last 2 minutes, I'm gonna just rewind it 2 minutes because this is a good little speech by Judge Slavin, and I've interrupted way too many times. So let's finish this off, and then we'll watch the bonus clip.
You have the potential to become a beneficiary, but until that person actually dies, you're just a name on a paper that might maybe happen. So you're not technically a beneficiary until you're actually a beneficiary because somebody died. So I really have no way of effectuating this case. So I am going to, one, sua sponte, dismiss your case for basically for lack of jurisdiction and for lack of subject matter jurisdiction. And as far as you could call your mom and ask for a copy, if she doesn't give it to you, she's the trustee. She doesn't have to. It's kind of like asking her for her driver's license. That driver's license is hers. You can't ask me to give you a copy of her driver's license. It's no different. She legally has the authority to hold and keep that paperwork because she's a trustee. So, I mean, I understand the situation and I can understand the frustration, and it saddens me anytime I see cases where family members are not are at odds in some way. Having just lost my father just a year ago, in a couple days, makes you think and makes you hope that you use the time.
Now, the only sob sit that was present, I just kicked out, or I put him in timeout. I put him in timeout for 30 minutes because I'm not going to be live for 30 more minutes. So he can watch from the sidelines. But there was a sob sit here.
You have available to, I don't know, be good and be kind to one another. But legally, I have no jurisdiction to make any ruling on this case at all. And for that reason, I have to dismiss it. All right? All right. Both parties have a blessed day.
Thank you, Your Honor.
All right. That's a fake end. That's a fake end. Bonus clip. Now, speaking of sovereign citizens, we're going back to Judge Slavin and what I think is a sovereign citizen. Now, this is either a sovereign citizen or someone that's abusing the system. Could be one and the same. Hold on. Let me get this set up. All right. Now, I know I said this already, but this is going to be my video release for tomorrow morning. My rule for bonus clips, as you all know, you don't have to rewatch it. I'm not going to make you rewatch it, but I would appreciate it if you get the notification, if and when you get the notification, I should say, because YouTube's not always great at notifications. Just jump on and hit the like button. I would appreciate it. That's my rule for bonus clips. All right. Now, this is a potential sovereign citizen in civil court, which we don't see very often. And I only say he's a sovereign citizen because he quotes Black's Law Dictionary and he makes some outlandish statements. Now, you know what? I'm going to stop it there. We're just going to play it. Where is broken system, broken trust, and we need him? He could probably explain the lingo to us.
This is Huntington National Bank versus Arnold, case 2302-4552 GC.
Mayor, I am so sorry. I pulled this up and I didn't call you out. Mayor, thank you so much for the 5 gifted memberships. Mayor, thank you so much. Again, beautiful service today. I'm glad that you let us all be part of it with you. And yeah, it was nice to watch you. Again, great eulogy. Now that I know the correct word. You're a great Googleizer. Thank you so much, Mayor, for the 5 gifted memberships and welcome to the 5 new members. All right, now let's go.
All right. Appearances, please.
May it please the court, Your Honor, Jeffrey Beers, P 41693 on behalf of plaintiff Huntington Bank.
And sir, your name for the record, please.
Chavez Arnold.
All right. Today's date and time.
Yeah, I'm not saying this guy's a sovereign citizen. It just the arguments he makes very much sounds like sovereign citizen-esque comments. So he didn't say he's a beneficiary. He didn't say anything about the trust. Again, it's very close. It's very close, but you're gonna have to wait and see.
Set for the bench trial on this matter. And Mr. Beers, you may call your first witness.
Thank you, Your Honor. Can you bring back Ms. Courtney Mack into the Zoom meeting?
There we go.
Um,
All right. Ms. Mack, if you could unmute yourself. Ms. Mack, do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Mr. Beers, your witness.
Thank you. Please state your name for the record.
My name, Courtney
Yeah.
Mack, sorry.
And Ms. Mack, who do you work for?
Huntington National Bank,
And what city do you work out of?
Huntington, West Virginia.
And what is your position at Huntington Bank?
Consumer Resolution Specialist.
And what is your title?
Consumer Resolution Specialist.
And did Huntington Bank enter into a credit card agreement with the defendant Chavez Arnold?
Yes.
And is this credit card account the subject of your lawsuit against Mr. Arnold today?
Yes.
And what are your job duties at Huntington Bank?
Litigation specialist, probate specialist,
And what are your responsibilities at Huntington Bank in carrying out those duties?
monitor litigation, trials, and work with probate clients.
Do you review accounts at Huntington Bank?
I do.
And do you review delinquent accounts at Huntington Bank?
Yes, I do.
Have you reviewed this account with Chavez Arnold at Huntington Bank?
I have not personally, no.
What are Huntington
But
Bank's?
I was going to say it has been reviewed.
What are Huntington Bank's customer record responsibilities regarding the record keeping of delinquent accounts?
To image the file into.
Okay, I blurred this out. There is a lot of personal details and financial records on this. Probably for the next, I'm gonna say maybe 5 or 6 minutes, the screen's gonna be blurry because my editing skills aren't that great. So I just blur out the entire screen so we can't see it. So that's why it's blurry. It's gonna be this way for 5 or 6 minutes. While I am paused, Louise, thank you so much for the Venmo. You say late fee. I'm just happy you're here. So thank you so much for being here and for the Venmo. I appreciate it. All right, but yeah, it's gonna be blurry for the next couple minutes, but we can still hear clearly.
Our system.
Okay. And you're familiar with this account, isn't that correct?
Yes.
Okay. And how are the account records of Huntington Bank kept?
Into our electronic system.
Okay. And do you have personal knowledge as to the account records of the Huntington Bank credit card account with Chavez Arnold?
Yes.
And could you identify this document marked as Plaintiff's Exhibit 1, which I've shared on the screen on this Zoom meeting?
Yes.
And go ahead and tell the court what it is.
The trial document.
All right. Is this
Credit
a
card
copy?
statement.
Is this a copy of the credit card file between the Huntington Bank card and Chavez Arnold, including the monthly statements on the account?
Yes, it is.
Is this document a true?
I'll do this so it doesn't, so you at least have something to focus on and it's not this just blurry document. I know some people don't like looking at the blur, so I'll split it in.
An accurate copy of the credit card file between Huntington Bank card and Chavez Arnold?
Yes, it is.
Was this record made at or near the time of the occurrence of the matter set forth by or from information transmitted by a person with knowledge of these matters?
Yes.
And was this record kept in the course of the regularly conducted business activity of Huntington Bank?
Yes.
And was it the regular practice of your business activity to make this record?
Yes.
And has it been altered in any way?
No.
Plaintiff moves to admit Plaintiff's Exhibit 1.
Mr. Arnold,
Yes.
anything for the record on that?
Yes. Ms. Courtney stated that this statement was a trial balance. And I would like
Well, if you're gonna ask her cross-examination questions, that's fine. I'll let you do that in cross-examination. Is there any objection to this being moved for exhibit to be plaintiff's exhibit 1?
Well, I'm kind of new to this. So you say, is there?
Do you have any objection to the entry of this document as plaintiff's exhibit 1?
As something that I owe?
I can't give you any legal advice, sir. I'm just
Okay.
asking you if you have any objection to this being exhibit 1.
I object.
Is it a yes or a no?
I object.
Okay, and your basis of your objection is?
That's not the trial balance.
Overruled. It's going to be the plaintiff's exhibit 1. Go ahead, counsel.
All right, you're gonna see what he's talking about when he says trial balance, and also we're gonna have some really funny things coming up. But that's the first thing that he said. This is why I think that he is sovereign citizen-ish. He used lawyer Google to help him with his legal arguments, and you're gonna see exactly what he has open on his computer when he shares his screen. So just wait.
All right, thank you. Ms. Mack, referring to plaintiff's exhibit 1, do they show all the purchases made by the defendant and all the payments?
That's coming up. That's coming up. You would be able to see it. You'd be able to read it if didn't have it blurred. But like I said, he's got a lot of personal information on this, and I'm not going to get in trouble for that.
Made by the defendant from April 5th of 2022 to February 28th of 2023.
Yes.
And referring to the statement the September 5th statement of 2022, which I'm going to scroll to here in a minute. There we go. Referring to the September 5th, 2022 statement, isn't it true that this statement reflects that the defendant made a last payment on the account of $196 on August 30th, 2022, and that's where my the cursor is pointed on August 30th, 2022. Isn't it true that it reflects that the defendant made a last payment on this account of $196 on August 30th of 2022?
Yes.
Okay. And
yeah, sorry, Mayor. I keep meaning to bring that up. I keep bringing your comments up and then pause and start talking about the video. Yes. This coming Friday, Mayor's going to be spending the night with me, and he's going to be on live stream with me this Friday. Well, he better be. That's the only. That's what I'm charging him to stay at my place in his travels. I think you said you're going to Texas, right? So is that your final destination? I don't actually remember where your final destination is. All I know is I'm gonna stop. He's gonna stop and hang out with me next Friday. So he will be on live stream with me. We're gonna be close enough to cuddle because my setup isn't that great. So, I'm gonna be living in his beard, or he's gonna be living in mine, even though my beard sucks. I'm trying to grow it out though. I'm trying. All right, let's keep going.
do the monthly statements, have they stated the annual percentage interest rate on the card?
Yes.
Did Huntington Bank receive any written objection from the defendant to any of his monthly statements before this lawsuit was filed?
No.
Did Huntington Bank receive any written objection from the defendant as to the interest rate on his monthly statements before this lawsuit was filed?
No.
What is the current unpaid balance on this account owed by the defendant to plaintiff?
$11,599.02.
Does the credit card specifically require that the balance be repaid along with all interest and late fees?
Yes.
Does use of the card, making purchases and making monthly payments on the card by the defendant constitute defendant's agreement to the terms and conditions of the card?
Yes.
Did the defendant fail to repay the remaining balance due on the card?
Yes.
Does the credit card specifically require monthly payments?
Yes.
And is Huntington Bank seeking judgment against the defendant, the amount of $11,599.02?
Yes.
Plaintiff has no further questions.
Mr. Chavez, Arnold, any cross-examination?
Can I go back to what I was originally asking, or is this moved on?
You have, this is the witness who they brought, and if you have questions on cross-examination of this witness, you can ask questions of this witness.
Okay, so you stated that this was a trial balance, that this is the trial balance of the account?
$11,599.02.
So this statement that you gave me, you're saying this is the trial balance?
Objection asked and answered.
Sustained.
Well, according to, let me see, according to Black's Law 6th edition, A trial balance in bookkeeping is a listing of debit and credit balances of all ledger accounts.
That's not a question. That's not a question.
She said it was a trial balance. This is a statement. There's a difference. There's a
Sir, the
difference.
trial balance, the trial balance of 11,599.02 is from all the credits and payments that are made on your ledger.
But there's two different things. In order for me to calculate my liability, I need the actual trial balance of this account.
And that's what this is.
This is from a period of April.
Objection. That's not in the form of a question.
Okay, questions.
It's an
Okay.
argument.
All right, got you. So the balance you say is 11,000. What was it?
599.02.
Okay. So is that number a positive number or a negative number?
That is the amount owed.
I'm just asking, is it positive or negative?
Objection asked and answered.
Sustained.
Well, let me see. Questions? Let's see, what else? Are you saying that all the debits and credits before this statement are completely accurate?
Yes.
And you verified that personally?
Objection, she
Yes.
testified that it's accurate.
I mean, you're stating that it's accurate, but I'm asking you personally verify.
And she answered the question by saying yes.
Okay.
Mr. Arnold, do you have any other questions?
Just a second.
Just a second. He's got to read through his script, and we don't. I don't want to spoil anything. Don't want to spoil anything. But yeah, just a second. He's got to read through his script.
Are you saying that I admitted to the liability of all of this debt because I failed to dispute it in time?
Yes.
Okay, will I have a chance to argue some of these things I'm talking about? Or is
You'll be able to have direct testimony from any witness of yourself or any witnesses that you call in.
Okay. Give me a second.
Do you have any further questions of this witness?
Just a second. No further questions.
Any redirect?
Plaintiff has no further questions of this witness.
All right, ma'am, you may step down, Ms. Mack. Thank you for your testimony. Mr. Asphalt, do you have any other witnesses?
Your Honor, plaintiff calls the defendant Chavez Arnold.
All right. Mr. Arnold, do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All righty. Mr. Asphalt, your witness.
Actually, Mr. Beers. Mr. Arnold, isn't it true that you had a credit card account with Huntington Bank with account number ending in 9810?
Yes.
Okay. And isn't it true that in your answer to the summons and complaint, you already admitted to the first 6 paragraphs of plaintiff's complaint, admitting to opening the credit card account with plaintiff Huntington Bank with account number ending in 9810?
Yes.
And you also admitted that you agreed to pay plaintiff for all transactions, interest charges, and fees assessed on the account in your answer to paragraph 6 of the summons and complaint.
Correct.
And isn't it true that you did make payments on this account for a period of time?
Pardon me?
Isn't it true that you made payments for this account for a period of time?
Yes, I've made payments on the account.
All right. And you made a last payment on this account of $196 on August 30th of 2022. Isn't that correct?
That's what the statement says.
All right. And the balance shown on the August 5th, 2022 statement, after which you sent in your payment, showed a balance of $10,150.27. Isn't that correct?
Is it, I'm not sure. Is that a positive number or a negative number? Because
I have no further questions.
okay.
All right, now, Mr. Asphalt, do you have any other witnesses?
It's Mr. Beers, Jeffrey Beers.
Oh, I'm sorry, Mr. Pierce.
That's all right.
Do you have any other, I was signing a different,
That's right.
do you have any other witnesses?
Plaintiff has no further witnesses.
All right, so Mr. Arnold, you are under oath. Now, are you resting your side of the case, sir?
Yes, Your Honor.
All right, so Mr. Arnold, now this is your case in chief. So you can call witnesses. You are under oath. So if you were going to testify, you can go ahead and testify now. You don't have to ask yourself questions. You can testify in the narrative. But at any time, if Mr. Beers wants to enter an objection, if he says objection, I would like for you to pause so I can find out what the objection is and then make a ruling on the objection before you go further with more testimony. Okay?
Okay.
All right. So, Mr. Arnold, your testimony?
I testify that pursuant to 15 U.S. Code 1692G, validation of debts, C, admission of liability, the failure of a consumer to dispute the validity of a debt under this section may not be construed by any court as an admission of liability by the consumer.
You screen share that for everybody so we can see what you're talking about?
Just a second.
Mr. Asphalt, can you take the screen share down on the?
Yes. Jeffrey Beers.
Mr. Beers, I don't know.
All right, blur is over. We're back. All right. Any suggestions for how you guys want me to do that tomorrow? Because that blur is way too long. I forgot this video is like 25 minutes. So yeah, that blur was a lot longer than 5 or 6 minutes. I want to do something. I also might fast forward when the attorney for the plaintiff is questioning the debt. I might just fast forward that. I might just speed it up at, I don't know, 1.5, even 2 times the speed. Because we don't really need to know all the numbers. We just need to know that he's in debt and he owes a lot of money. So I need to do something for this video. So maybe I'll wait till tomorrow evening or even Monday to release this. Anyways, I'm rambling. Now we get to get to some funny things.
There we go.
Pulling it up now, Your Honor, just a second. Share screen.
All right. Two things I want to say real quick. First, not blurring out the phone numbers of the attorneys on the right. They're actual attorneys, and those are their business numbers. So if you guys want to call them, give them business, by all means, call them and give them business, but they're not personal phone numbers. I want to, what I do want you to look at is look at the tabs he has open. The second tab he has open, it's blurry on my screen because it's small. What does it say? Okay, I gotta hold on. I'm taking myself off the screen so I can read it. You guys might be able to read it, but I can't. When I'm streaming, my screen is actually fairly small. How to prove and apparently I've been on mute. And apparently I've been on mute. Anyways, yeah, you guys can see what the tab is. It's kind of hilarious. So he Googled how to beat this, and this is the article that came up, and he's trying. He's trying.
Hang on 1 second so I can pull it. Just go up to the top, please. I'll pull it up on my own computer. Okay, so this is reading at the same time. Okay, so go ahead.
Pardon?
Go ahead.
With
Your testimony? What is it that you're, whatever you're gonna testify to?
okay, just a second. I testify pursuant to 15 U.S. Code 1666D, treatment of credit balances. It says, whenever a credit balance is in excess of $1 is created in connection with a consumer credit transaction through one transmittal of funds to a creditor in excess of the total balance due on an account, 2 rebates of unearned finance charges or insurance premiums, or 3 amounts otherwise owed to or held for the benefit of the obligor, the creditor shall credit the money, like credit the amount of the credit balance to the consumer's account. B, refund any part of the amount of the consumer credit balance upon request of the consumer. And C, make a good faith effort to refund to the consumer by cash, check, or money order any part of the amount of the credit balance remaining in the account for more than 6 months, except that no further action is required in any case in which the consumer's current location is not known by the creditor and cannot be traced through the consumer's last known address or telephone number. I testify that the balance that they state that I owe is a positive number, and according to this United States Code 1666D, it's a credit balance.
Okay. It is a credit card balance, correct? Do you have any other Do you have any testimony with regard to anything else?
Yes, just a moment. I testified that pursuant to 12 USC 831N, that financial institution is required to keep certain accounting standards, and those standards and objectives supposed to be in accordance with the principles of GAAP. And I testified that that statement that was provided is not trial balance in accordance with GAAP principles of accounting.
And why?
Pardon me?
Why doesn't it not comport?
Because the GAAP principles of accounting says that the general ledger should be listed all debits and credits, all money going in and out of the account, as well as checks paid to and from the account, as well as the trial balance with the debits and credits being correlated, zeroing it out.
Yeah, this guy's a genius. He doesn't realize he just admitted to everything. So yeah, they already showed the ledger. They showed the credits and debits going in and out. They showed you paying. This guy has absolutely no idea. All right, I withdraw. This guy's not a South Sit. He's just a guy that's using attorney Google. That's what he's doing. I feel like if he was charged with a traffic crime, he would turn into a South Sit though. This is the kind of person that would absolutely turn into a South Sit. Yeah, I mean, I love how Judge asked him why though, like why, and then I mean, he said an answer. I didn't think he was going to say an answer.
Okay, continue.
Just a second.
Do you have any other testimony?
Looking, I'm sorry.
Credence and Mikey, good to see you. Or sorry, Mikey, good to see you. I know better than to do that. But good to see you, Mikey. Hopefully you're doing well, and hopefully you're looking forward to getting your ass beat in some fantasy football. Mikey's a part of the league. So is Jay Hart or Drunk Beaver Productions. Yeah, it's gonna be a fun league. It's gonna be fun. Stay tuned. We're doing the draft. I think the draft is gonna be on September 1st. Is what we're doing. And yeah, it's going to be a lot of fun. We got a lot of good people in the draft. And because this is a bonus clip, I don't mind pausing a lot. But now that I think we have the roster finalized, I will go ahead and tell you guys the roster. So we have, let's see, Mikey, myself, Heather, Jay Hart or Drunk Beaver Productions. We have People in Court, KCC, Judge Fleischer, Judge Slavin, Team Skeptic. Let's see, I'm missing three. Lone Wolf. Lone Wolf will be there. Jen Hardy. Oh no, this is why I don't do lists. I always forget somebody. Who am I missing? Hey, there's Heather. Speaking of Heather. Who am I missing? I don't know. I can't remember who I'm missing. This is why I don't like doing lists on the fly. And now I gotta look. Hold on. Who did I leave out? No, I feel like I just named everybody. Oh, Team Skeptic's son. Team Skeptic's son is playing as well. There we go. All right. That's all 12 of us. Yeah, look forward to that. No, Biggin said he wasn't a big fan of football, so he didn't want to play. I did ask him though, but he's not a football fan, so he didn't want to play.
I testify that I'm not refusing to pay, or if anything, I'm really just trying to calculate the liability of the account in accordance to the GAAP principles with the general ledger and the trial balance. And I have no further testimony.
Mr. Mr. Beers, when they put the screen share up, your screen is so tiny, and you and Mr. Asphalt look very, very similar from my old eyes, from far away on the screen. So, Mr. Beers, any cross-examination?
Plaintiff has no further questions.
All right. Closing statements.
Your Honor, you've heard the testimony of the plaintiff's witness that defendant had a credit card. Plaintiff's witness that defendant had a credit card with the Huntington Bank. Defendant, in his answer to the summons of the complaint and his testimony here this morning, has already admitted for the first 6 paragraphs of the plaintiff's complaint, admitting to opening the credit card account with plaintiff Huntington Bank with account number ending in 9810. And he admitted that he agreed to pay plaintiff for all transactions, interest, charges, and fees assessed on the account. That's paragraph 6 of our complaint, which he admitted to. Pursuant to the monthly statements which have been admitted into evidence in plaintiff's exhibit, defendant was required to make regular payments on any outstanding balance on the account. The defendant last made a payment on the account of $196 on August 30th, 2022, as reflected on the statements. The defendant subsequently defaulted under the agreement, leaving an unpaid balance which continued to accrue charges and interest pursuant to the credit card. Following default, the plaintiff filed suit to recover the balance under breach of contract and under the Michigan account stated statute MCL 445.862A. Defendant's use of the charge account constituted his acceptance of the terms of the agreement and was sufficient to form a contract under the Michigan account stated statute MCL 445.862A. Further, under Michigan case law, the Court of Appeals has found that use of a credit card to be sufficient evidence of a cardholder's assent to the terms. That's American Express versus Redner, which is docket number 264904, Michigan Court of Appeals, and Jones versus Citibank, 235 Southwest 3rd 333. The language of the customer agreement is unambiguous and requires timely payments of purchases, interest, and fees as a condition of extending credit to the defendant. By failing to repay the amounts charged, the defendant breached the terms of the credit card, and plaintiff is entitled to repayment of the balance. No signed contract is required under the account statement statute 4862A. The use of the card and payments made on the card in response to the monthly statements being sufficient to establish liability to repay what you have charged. We've supplied monthly statements on the card, itemizing all the purchases made on the card, and more importantly, payments made on the account by the defendant without objection. The payments were made by the defendant without objection in response to the monthly statements, which creates an account stated and establishes liability for same. The law does not require a contract with a signature. Plaintiff has established by preponderance of the evidence that defendant had the account, that he received the statements at his address, and that he made payments to plaintiff on the account in response to the monthly statements without objection. The defendant has not produced any written documentation or accounting or evidence to rebut plaintiff's exhibit, but rather seems content to rely on plaintiff's accounting. In light of the evidence and plaintiff's testimony, defendant has stated no defense to the case, and plaintiff requests judgment against the defendant in the amount of $11,599.02. And further, under the generally accepted accounting principles, the positive number on a credit card means that you owe money to the bank. And I mean, that's been the law since forever. If you're owed a credit, it would be a negative number. Plaintiff rests.
All right. Mr. Arnold, closing statements.
Closing statements. Johnson versus Johnson, 195 Michigan Appeals Court, 199-1992. Since the Michigan Court of Appeals ruled that the trial court should have been more lenient with the procedural mistakes made by the pro se litigant, emphasizing the need for fairness and the right to be heard. And I pray for that. When I filed the answer, I said I disputed the amount. I was under the assumption that this was a pretrial and I have the opportunity to get that accounting so I can understand the true nature of truly what was going on here. pursuant to the 15 U.S. Code 1692G, C, me failing to respond or dispute it, and all these things does not cannot be construed by any court as an admission of liability by the consumer. And if I do dispute that, they should be able to verify those records that I asked for and not produce just a statement of the last transaction. According to GAAP procedures, a positive number is in an asset account reflects a credit balance. So I don't know where he get that at, but I could, that's the type of things that I would want to get clear on, and I request that I'm able to, get an understanding and get this information that'll clear things up for justice and a fair trial.
All right. I think we all understand what's going on here. I'm going to let this video play out. Thank you so much for hanging out with me today. You guys are awesome. And yeah, if you haven't done it already, please hit that like button. Also, thank you to Lone Wolf for the raid. If you haven't checked his channel out, jump over to his channel. Credence and Mikey, thank you so much for hanging out. Another great channel. I feel like you guys already know about both of them. Also, yeah, Noah.
Having heard all the evidence, do you find that the plaintiff has established that?
No, my headset, my earbuds are dying is what's going on right now. So I got to make this quick. You guys are awesome. I wasn't muted. My earbuds are dead. So now I have to go. You guys are awesome. Have a great Saturday night. Don't do anything dumb. Be safe. I will cover you in court if you end up in court. So you don't want that. Have a great weekend, everybody. I will see you tomorrow. Until next time. Bye.
There is a credit card account that was.
I forgot Drunk Beaver. Sorry, Drunk Beaver. Again, this is why I don't make lists on the fly. I hate making lists on the fly. All right. Yeah. Also, another great channel to check out. Okay. Now I'm done. Bye.
Opened by Mr. Arnold. He used that account, made several purchases and charges, made some payments as well. Last payment of $196 back in 2022. Then there was no more payments on there. The Exhibit 1 is a conglomeration of all the statements showing all the charge payments that were made to the account and from the account. This is not, let the record reflect that this is also not an asset account. An asset account is like a CD or money market type of account where it's an investment account. This is a credit card account where it's always just credit that's being loaned or given out to somebody in a certain total amount, and they can only use that amount of credit. There's never any asset in the account. It's just somebody's telling you that they'll pay for you in a minute, you pay us back with interest. That's not an asset account. So you're correct in your statement that a positive number in an asset account would be a credit. It'd be a credit to you, but it's not. Has nothing to do with a credit card account. Secondly, the proper statement of account stated in Michigan law under the statute of Michigan is what we're following here. And I do find that there is a total balance of $11,000 with interest of $11,599.02. Cost of $160, motion fee of $20, and statutory attorney fee of $75. Are there any other costs, Mr. Beers, that I was unaware of?
Plaintiff has no further costs, and we are waiving our filing fee and service fee and statutory attorney fee. And we would pay only
Okay.
$11,559.02. And we
So you're waiving, on the record, plaintiff is waiving the filing fee, the statutory attorney fee, and the motion fee. Is that correct?
That's correct.
Court will eliminate the judgment amount. Total judgment being $11,599.02. Now, Mr. Beers, please send that in via the portal or email, the judgment, and all parties will receive their true copy in the mail.
I will do so.
Mr. Arnold, if there is a need for a payment plan, you can file a motion for installment payments on that, and then the court will go through and look at your ledger, like what your monthly bills are versus what the payment, proper payment should be.
How would I go about getting a transcript for this?
I can give you the phone number. It's 734-374-1339. Then you just give the case number, which is the 2302-4552.
All right, thank you.
And there is a transcript fee that goes along with that, but you can discuss that with the recorder.
Okay.
All right, everybody have a blessed day.
All right, I hope you guys can hear me before I peace out. I just looked to see if I could raid anybody. I don't know. We're set to raid Meg. Hopefully it works. I don't know. I don't know what's going on with my computer right now, but it's not happy with me, and my headphones aren't happy with me. But we're set up to raid Meg. Tell her I sent you. Go check her out as well. She has a great channel. Okay, now I'm done. Bye.
Thank you.
Thank you, you too.